Okay, councillors, if you'd like to take your seat, we'll get rolling along and try to beat the shortest meeting yet. Welcome everyone to tonight's meeting of the Urban Planning Delegated Committee. Before we commence the meeting, I request that all mobile telephones are switched off or turned to silent. Thanks very much. My name is Councillor Westgold and I chair this committee. I will start by introducing my fellow councillors. Seated on my left is Councillor Lisa Hollingsworth, Councillor Shima Ibuki, Councillor Sophie Tourney, our Mayor, Councillor Michael Nolan, Councillor Felicity Sinfield. On the other side of the horseshoe table is Councillor Victor Franco, our Deputy Mayor, Councillor Mal Osborne-Smith, Councillor Rob Ballieu, and in the large screen behind me, Councillor Chris Pattis. I also acknowledge Manager Governance and Legal, Mr. Brian Wee, to my left, and Director Urban Planning, Mr. Scott Walker, on my right. There are other officers here tonight and they shall be introduced as they present to us. The Urban Planning Delegated Committee meeting is being live streamed on the Council's YouTube to enable viewing of the proceedings. The meeting is also being recorded and will be made available on the Council's YouTube again as soon as practicable after the meeting. The primary purpose of the Urban Planning Delegated Committee is to deal with issues under the Planning and Environment Act and the Building Act. This committee has delegated authority to make decisions on behalf of Council. Now, the next portion of the general introduction is directed at the audience who are speaking tonight, and I understand no one is speaking tonight, so I might just skip that and move forward. I'd just like to say, for those in the gallery, and I'm sure they will, I'd like you to behave yourself and due courtesy to each other and to the councillors. Thanks very much. Just to finish, I would like to encourage all submitters, that there are none, officers, etc., and councillors to speak directly into the microphone so we can share our thoughts. So I'll move directly on to apologies. Mr. Wee, are there any apologies this evening?
Through you, Chair, Councillor Fran Pereira is an apology this evening.
Thank you. I'll move on to adoption and confirmation of the minutes of the meeting, Urban Planning Delegated Committee meeting held on the 7th of July. Can I have a motion to adopt and confirm these minutes? Councillor Sinfield.
Love to help you out, so moved, Chair.
Oh, thank goodness for that. Do we have a seconder? Councillor Osborne-Smith.
So second, thank you.
Fantastic. Is anyone opposed? No one's opposed. I will now put the motion. All of those in favour? No one's against. I declare the motion carried. Declaration of conflict of interest of any councillor or council officer. Council officers, are there any conflicts of interest that you wish to foreshadow for the matter on the agenda tonight? There are none, thank you. Let's move straight into it. Presentations of the officers' report, tree protection, planning controls, endorsement for public consultation. And tonight we have Nick Brennan, Senior Strategic Planner, to present to us.
Thank you, Chair, and through you. The purpose of this report is to provide the UPDC with a summary of the outcomes of a review of Council's tree protection regime and to seek a resolution to endorse draft planning overlays for public consultation. Tree removal applications on private land are currently assessed under Council's tree protection local law. This requires a local law permit for removal of canopy trees and for removal or pruning of trees on Council's significant tree register. The existing tree protection regime under the local law has revealed some shortcomings, such as the ability to overrule the local law through the building permit process in cases where a private building surveyor can issue a permit to construct a building, which necessitates the removal of trees, which when they then come to Council to request removal of that tree, we are unable to prevent. Officers are recommending that tree removal considerations be shifted into the planning permit assessment process. This will have the following benefits. An earlier consideration of trees in the development process before siting decisions are made and development permits are issued. Greater transparency for landowners and purchasers, as the planning controls will appear on planning certificates and in Section 32 paperwork. And will also provide a clearer appeals process through the VCAT process against planning permits. Vegetation protection tools available within the Victorian planning provisions have been reviewed by officers, and 2 planning overlays have been identified as the most appropriate tools to govern tree removals through the Burundara planning scheme. These are an environmental significance overlay, or an ESO, which has been drafted to apply to sites with trees on the significant tree register, and a significant landscape overlay, or SLO, which has been drafted to apply broadly across the municipality to protect canopy trees that aren't on the significant tree register. These overlays provide planning permit triggers for tree removal, as well as for buildings and works within the root zones of trees. It's proposed to consult the community on the draft overlays before returning a report for the consideration of the UPDC to decide whether to carry out a planning scheme amendment to incorporate the draft overlays into the Burundara planning scheme. So officers recommend that the UPDC resolve to endorse the draft ESO and SLO for public consultation. Thank you.
Thanks very much, Mr. Brin. As there are no speakers tonight from the gallery, I'll move straight to councillors' questions. Councillors, are there any questions of officers? Councillor Tawney.
I do have some questions. I'd also like to foreshadow a motion for when the time is right. Thank you for the report. Thank you for the comprehensive report. I'm just interested in what the next steps are post-consultation, what the next steps are and what the likely time frame is for that.
Through you, Chair. So once consultation is completed, officers will review the submissions received and prepare a report summarising those findings to come back to the UPDC. The decision for the UPDC at that time will be whether to proceed to a planning scheme amendment. Should the UPDC resolve to go to an amendment, officers will write to the Minister for Planning to seek authorisation. If the Minister grants authorisation, we will then begin the formal planning scheme amendment process, which will involve exhibition of the controls to the municipality. A report will then be prepared summarising submissions for consideration of the UPDC. It is likely that submissions will have to be referred to a planning panel for consideration. The planning panel will then prepare a report and back to the UPDC to summarise those findings, and then to a council meeting for adoption and submission back to the Minister for Planning for approval of the proposed amendment. I've fairly rapidly summarised and cut out some decision and some flakiness there, so forgive me for maybe trying to be brief in the answer. In terms of timing for that, a rough guide for a planning scheme amendment is around 12 to 18 months from authorisation to adoption and submission to the Minister. You'll note there are some asterisks in there around authorisation and approval by the Minister. There is no set timeline for the Minister for when they have to make a decision on those, so that makes it very difficult to give a comprehensive answer on when exactly we will complete this process. I can tell you how long the council parts of it take, but the Minister for Planning can take longer to make decisions on their part.
Thank you. And if I may, through you, Chair, what impact would it have if the state government introduced metropolitan-wide planning controls? What would then happen with this? Assuming we're somewhere in between the 12 and 18-month process.
Through you, Chair, if the Minister for Planning was to introduce tree controls that affected the entire municipality, officers would review those controls and determine whether they were of a similar robustness to what we were proposing, whether they picked up the same number of trees. If they did, then we could abandon the amendment process we were underway or modify it to address any shortcomings we identified in the Minister's proposal. It's also likely that the citywide controls from the Minister would not address significant trees, so it's likely that we would need to continue with the significant tree register specific amendment, given that is of a more specific and significant nature.
Councillor Franco.
Thank you, Chair. My question's very much along the lines of the first question that the Mayor asked. So through you, the proposal before us is to go out to consultation, but prior to seeking approval from the Minister. So I'm trying to get an understanding of why we would go out to community consultation now, then seek approval from the Minister, as I've understood your question. I was going to ask the question separately before, and then go out to consultation after we've obtained approval from the Minister to go out for consultation. Wouldn't we be better just going to the Minister now, seeking approval to go out to consultation and then going forward? Or have I missed something in that?
Through you, Chair. No, Councillor, you haven't missed something. This is Council's general practice when proposing changes to the planning scheme and introducing changes that can have a material change to people's properties, is to make sure that we have notified them before we take any actions that can begin to have a change, as opposed to them finding out once the change is proposed. Because once a change to the planning scheme is authorised, it starts to appear on Section 32 notices, and people can then, for instance, change their decisions about whether they want to buy a property or not based on a change that is proposed. So we want to make sure that people are aware of any change, or aware that Council is investigating a change before we have any material impact on their properties that may change any decisions they could make.
Thank you. And one follow-up question, Chair. Just to be absolutely clear, the proposal that we've got before us from officers is the proposal that ideally, this community consultation aside, would be what we'd expect the Minister to approve for us to go out in relation to a planning scheme amendment. Is that correct?
So through you, Chair. Yes, this is what officers have drafted with the expectation of undergoing and applying for an amendment. That said, we could get feedback from the community that they want changes made to these controls, and they could be entirely justified. So we have an opportunity to take those on board before commencing the amendment process and seeking authorisation.
Thank you. Thank you, Chair.
Councillor Hollingsworth.
Thank you, Chair. Question for officers. Mr. Brennan, I'm not sure if you'll be able to answer this, or perhaps it might be for Mr. Walker, but there's a correlation between this proposed policy going out to consultation and obviously awaiting community feedback, but also with the CASB group with regard to the environmental sustainability and design standards. And I know CASB have been liaising for some time with the government to try and have some controls put into the planning framework to help us better enforce sustainable design. And I just wanted to ask if CASB is also working with regard to tree control, because that's an integral part of planning, and so whenever there is a demolition permit approved and, you know, a block of land is moonscaped and all the trees are gone, is there some overlap with what CASB are doing as well? And sorry if you want to explain what the acronym is for CASB for the benefit of the community listening.
Through you, Chair. Yes, so CASB stands for Community Alliance for a Sustainable Built Environment. It is a group auspiced under the MAV, which is many Victorian local councils seeking to improve sustainability measures, specifically through the planning process. Yes, there are some overlaps in this policy and through the sustainable design policy that has been put forward by CASB, and that this council is one of the councils seeking authorisation for an amendment. That is a much broader amendment, policy that deals with many different aspects of planning and has some vegetation and landscaping provisions within it. It is more about landscaping of built projects and vegetation being planted as it is retaining vegetation on site. So this is much more about the trees that we have and seeking to retain those. And that is, the CASB policy is more about improving the greening of built projects and what goes in through the landscape plan or garden plan or whatever as part of those.
Thank you for binding clarification. Thank you.
Councillor Osborne-Smith.
Thank you, Chair, and thanks very much for your efforts in drafting this policy, which I thoroughly support. Two questions, if I may. The first is in relation to the interim period, next 18 months or so, pending, let's hope, endorsement of this change to our planning scheme. I'm just trying to get a feel for what risk, if any, in your opinion, there may be that once this document's made public and consultations sought, that there could be a raft of applications, building permit applications or planning applications to get in before changes are made, and whether you assess that as a risk, and if so, is there any measures that we can take to mitigate that risk? And the second question, which is a little related, is do you have a feel for, because of the gravity of this change, and it's a citywide overlay, do you have a sense of what landowners, what property owners may be appealing decisions or pushing hard to remove trees on their land for, I'm assuming, mostly development sites, and in which case that may lead to extra appeals to VCAT, etc., that our council may have to face in the years to come?
Through you, Chair. So a benefit of the current provision we have in place through the local law being translated into a planning scheme provision is that the local law remains in force while we are carrying out this amendment. So essentially, we already have, if I could draw a parallel to when we are proposing a heritage overlay on a property, for example, where previously there is no control, we often seek an interim provision in that case because there is a lack of controls. In this case, we have the local law in effect, so we already have a trigger to require permits for tree removal. We're also proposing these controls as a continuation of those same provisions, but translating them into the planning scheme as opposed to through the local law. So we're aiming for a continuation of practice and a continuation of effect on property owners in terms of similar trees will be requiring a permit just through a different process. So the, what am I trying to say?
If I could assist
Yes.
to just expand on that answer, if I may, the reality is that the reason for these changes is that the current local laws are inadequate in some areas, as I understand, where you apply for a building permit, which allows a wholesale removal of trees potentially on a site. So that's an area we're trying to close off. I'm just wondering if, because of this interim period of 18 months, there may be a spate of building applications or the like that may be crystallised with the desire to try to remove trees before the planning scheme's amended. A tricky one to answer, and perhaps it's a little unfair, that question. I'm just concerned about that.
Perhaps if I just touch on that, and the simple answer is yes, there is some risk. There may be an increase in applications. However, we are in a fortunate position that we already have a tree protection local law that triggers a permit requirement for tree removal in a majority of situations. So we are actually in a better situation than another council that may well not have that protection and is seeking to do a similar thing. So we are in a strong position, but there is some risk.
Understand. Okay, thank you. And my second question, which was just about post 18 months when this, let's hope, planning scheme amendment is approved, do you have any sense of whether, because it's a much more strict process, that it may lead to a lot more concerned property owners trying to remove trees for development sites that are not able to, and whose applications fail, and end up appealing those decisions to VCAT, and whether we're likely to become a more litigious council. Again, a difficult question to answer, I appreciate that.
Perhaps if I could just touch on responding to that as well through yourself, Chair. The process under the planning scheme is not necessarily a more involved or more stringent process for protecting trees. What it is a more integrated process for considering building matters and trees in a holistic way, whereas the tree protection local law has no link to consideration of these building and planning type matters on a site. So it's the integrated nature that gives us our significant benefit under the planning scheme. It's not necessarily a more involved or stringent process in terms of the assessment and considerations and outcome. Now, there is also, however, an appeal opportunity. If an applicant is unsatisfied with a council decision, there is an appeal opportunity to VCAT, which doesn't exist under the Tree Protection Local Law. So there is some potential that we will have more matters go to VCAT and are overturned in terms of council decisions. However, having come from a similar council previously, and been involved where there are planning scheme tree controls across the entire municipality, that is much, much lower than what might be a concern. So the number of matters for tree removal that end up at VCAT is actually quite small, and will be quite small.
Thank you very much.
Councillor Nolan.
Thank you, through you, Chair. Thank you, Mr. Brennan. I've really enjoyed reading these two proposed changes under our planning. Just in relation to the fines that can be issued for illegal removal of either significant or canopy trees, would you mind just, for the benefit of councillors and also for the people who might be watching this, residents, just outline the impact in terms of fines by moving from a local law to the planning scheme, please?
Through you, Chair. Certainly. So, under the local law, the current provision, there is a maximum penalty of 20 penalty units. Penalty units used by the state government to affix a number and then multiply that by the number of units to get the fine. 20 penalty units is around $4,000. Under the planning scheme, an investigating officer can issue a fine of a maximum fine of either 5 penalty units to an individual or 10 penalty units to a company, which is $1,000 or $2,000. And but by undertaking court action, so through the Supreme Court, Magistrates Court, sorry, can be issued a penalty of up to 1,200 penalty units. Sorry, I'm reading and trying to speak out loud at the same time. Maximum penalty is 1,200 penalty units, so that's around just under $200,000. So that would require a court action. It couldn't be issued by an officer, but it is higher than what's available under the local law.
Just a quick follow-on question. So we would drop the penalty and move from local law down to significant drop under the planning scheme. The fines would be less than under the local law. Is that correct?
Through yourself, Chair, that is correct for infringements issued by officers. However, the penalties that can be obtained at the Magistrate Court would be much more significant. So the ability to pursue matters and fines at the Magistrates Court give a much greater potential for higher penalties than under the Tree Protection Local Law. So you're exchanging one for the other. The other thing about the planning scheme and enforcement action under the Planning Environment Act. There is a much greater ability to put conditions against a planning infringement, so obligations and requirements in regard to replacement planting or other actions. And there is also the ability to take alternative enforcement action, such as enforcement orders that would prevent a particular action. So it might be an intervention to stop tree removal while it's underway, or other obligations and requirements around enforcement orders that can be issued by VCAT. So there's a much wider range of enforcement opportunities under the Planning Environment Act.
Thank you.
Councillor Pattis.
Thank you, Chair. I'm just going to make a comment and ask a question. I feel that there's some risk here. I think this is the right approach, but there's some risk that things could go wrong, and this is why I think our problem is not with this. I feel that our problem is not in the significant tree area, but the problem is in the canopy area, where we're having issues in terms of enforcement. And by combining these two, the significant tree planning control and the canopy tree planning control, and going out to the community, I feel that there's a risk that we could either confuse the community, we could get feedback on one and not the other, and therefore maybe misinterpret what the community wants. And the other issue, of course, is that the state government, the direction that it wants to take through the planning minister, if they decide that we're taking the wrong approach on one, for example, on the canopy tree, may also penalise us on the significant tree. So I feel that by combining these tree controls, that we risk there could be a complication, or it could take a lot longer, or in fact we could have unintended consequences. So my question is, have you considered, and why didn't we take an alternative approach to go out to the community with two separate controls, the significant planning control, significant tree planning control, and the canopy tree planning control, and therefore maybe have a more straightforward process, and one that doesn't have the risk of confusing the community?
Through yourself, Chair, that has been thought through very carefully. At one stage there, we were looking at having a single form of control that would potentially cover both significant trees and canopy trees. We have actually taken a very deliberate strategy of having two separate types of controls that would apply separately to both significant trees, and a separate control that would apply to canopy trees. So in fact, the strategy that's been put forward by yourself, Councillor Pattis, is the exact strategy that we're taking, even though that is in the one report that's being brought forward here. We are aware of other councils that have approached tree controls for canopy and significant trees in a similar way, and there is a potential that if we do not receive authorisation for one of these controls, that we may for the other. And we have a lot of confidence around the significant tree control and taking that forward as a separate matter.
Thank you.
I'm sorry, through you, Chair, again. It sounds like what you're saying is that going out to the community with two separate consultations is a better approach. Going out maybe first with a significant tree planning control, getting the community response, and then approaching the planning minister, and then separate to that, the canopy one. It sounds like from your argument, the way I interpret it, that's a better approach, because we don't risk the two being confused and the two maybe affecting each other. I'm a bit confused with your answer, I'm sorry.
Through yourself, Chair, we plan on going to consultation at the same time. However, be quite clear that there are two separate controls, one that applies to significant trees and one that applies to broader canopy trees. We don't think that there is a risk or a concern in presenting them at the same time. I think this is about taking the approach under the Tree Protection Local Law, which has both significant trees and canopy trees now. It's about taking that approach forward as a conversion over to a planning format, a planning scheme format, as opposed to coming up with something new.
Thank you.
Sorry, through you, Chair. So you don't think the community is going to confuse the two? In other words, understand the difference. So you're quite certain that the community understands the difference between a significant tree and a canopy tree, and therefore we'll have really good responses.
Yes, I am, and if we are undertaking the consultation and we receive feedback that does confuse it, we will use that as an opportunity to provide further education and clarify when we move forward at the end of that consultation period.
Thank you, Mr. Walker.
Thank you.
Further questions? Councillor Hollingsworth, your light's still on. You've exhausted your questions?
I have, thank you.
Thank you. Councillor Franco.
One further question, Chair. Thank you. In relation to the Section 32 paperwork, can officers advise what would appear? Would it be, and it may be separate for significant trees versus canopy trees, but are we simply talking about the generic clauses from the planning scheme or the specific identification that there's a canopy tree and or significant trees on site?
Through you, Mr. Chair. The Section 32 includes the planning property report, which is sought at through the state government, and that is a fairly straightforward report that just lists the zones and overlays that apply to a site. It wouldn't go to the level of detail of specifying that this specific significant tree was on the site, but it would flag, if there was a significant tree, that they were subject to the proposed ESO, which would apply to significant trees, which they could then go away and determine which tree it was that was on their property, or on the property.
Thank you.
Thanks very much. We now do appear to have exhausted questions from councillors. I will now return to Councillor Attorney to move a motion.
Thank you, Chair. If we could have the motion up on the screen, I propose an additional point to the officer's recommendation, which includes writing to the Minister for Local Government in support of the government's target to achieve 30% tree canopy cover, and request that there be a significant increase in fines able to be imposed by council under its tree protection local law.
So
as a deterrent, yeah.
Have we had enough time to read that? Are you happy with that? I'm now in search of a seconder. Councillor Hollingsworth.
I'd be very happy to second, thank you.
Terrific. Is there anyone opposed to the motion as it now appears on the screen?
Chair, I have a question, if I may.
We've really gone past the question time, I think. Can we leave that?
Well, it's the first time I'm seeing this amendment, Chair, and I want to ask a question about the 30% figure.
Okay.
How can I vote on something I don't understand?
That's fine. Councillor, would you be happy to explain that? That'd be great.
So the 30% figure is the figure of the state government that it has set as its target for tree canopy cover. So we're in support of...
On private land?
That's not our figure, that's the government's figure.
Okay, that's not the private land. Is that overall or is that
Overall.
private land?
It's overall.
Okay, thank you.
Okay. So I shall ask again, is anyone opposed to the motion as it currently appears on the screen? There doesn't appear to be so. Councillor Tawney, would you like to speak to your motion? Thank you.
Just very quickly to thank the council officers for producing this report, and I'm very pleased to support it, and I'm glad it's going out to consultation. We all know the value of trees, whether it's for shade, biodiversity, cooling our ever-warming planet, and to get to that 30%, our own target is 27%, but to get to 27 or 30%, we need trees on private land. And I think that this proposal, as much as it will take time, is the step in the right direction for that. Early consideration of trees in the planning process is vital. We need strong protections, and if we're going to stop this slow erosion of our urban forest, this is what we need to do. So I think it's about setting really clear expectations and being very transparent with the community. And that third point I added in because I think we need to make sure that the community understands that we value trees and there is a significant fine if trees are illegally removed or destroyed. Trees matter, and I commend this to my fellow councillors. Thank you.
Thank you, Councillor. Councillor Hollingsworth, will you care to speak at this time?
With your indulgence, just briefly, because this is such an important issue. First of all, I just wanted to reiterate the Mayor's comments and thank Mr Brennan as the Senior Strategic Planner for preparing this report before us tonight and for answering all of our questions in great detail. Thank you. This document is very good. It is going to consultation and we will be very interested to hear what our community have to say. But I'm now into my 9th year as an elected representative, and sadly the erosion and desecration of trees is escalating at a rapid rate, and the existing controls sadly are not a strong deterrent. And so if this is supported with community feedback, with council endorsement and ideally with support from the relevant minister, this will help Burundara Council have greater oversight on protecting trees on private land with the 2 environmentals, significant overlay and significant landscape overlay. Our community can be assured that with trees on their properties, there is a very, very stringent decision guideline process that council officers must adhere to. So we don't take it lightly. This is a matter that we've all given great consideration to, and I would strongly recommend to my councillor colleagues that we support it. Thank you.
Thank you, Councillor. Whilst we're going very well tonight time-wise, if anyone else desperately wants to speak, even though this is out of order for something that isn't opposed, if you've got a very quick comment to make, I'd be happy to accept it, but please, if it's been said already, don't. Councillor Buki.
Thank you, through you, Chair. Just very briefly, as a councillor, one of the most common requests for discussion emails that I get from residents are around tree removals. And I think that many of us here value our tree, our canopies, and I would just like to thank council officers for their foresight in drafting this amendment, and I also support it and urge my fellow councillors to do the same. Thank you.
Thank you. I'll just add, Councillor Franco.
Yeah, look, I thought I'd add one additional comment that an element of this approach is having an appeals process to VCAT, and I've had lots of inquiries over the years from residents who have been dissatisfied with the internal appeals process that we've currently had, and I think having that greater transparent appeal mechanism is a good thing, and it's an element of the approach here that I strongly welcome. Thank you.
Thank you, Councillor. I might now make my very brief comment. In the 4 years I've been on council, a little bit more, one of the most embarrassing things I've had to handle is to tell residents that there's very little we can do in real terms to save trees on private land. And I've asked the question, why didn't we do this years ago? And the explanation is that we've really only become aware of the shortcomings of the local law proposals increasingly over the last few years. So it's delighted now to see this going ahead. But I think, as Mr. Brennan has warned us, this could be a long process. And we might not get the both accepted. Let's hope we do. But I wish you all the luck in doing so. Thank you very much. I will now put the motion to a vote. All of those in favour? The motion is carried. Thank you very much. We'll now move to the finalisation of the meeting. General business. Councillors, are there any items of general business for this evening? There are none. Urgent business? There are none. Confidential business? Likewise. Thank you. Before I close this meeting, I want to thank all of you who have joined us in the chamber or on the YouTube. I declare the Urban Planning Delegated Committee meeting closed. Thank you very much.